And continuing on with our series of historical landmark U.S. Supreme Court cases, we have Horton versus California. And this case was decided in 1990 by the U.S. Supreme Court. This was the Rehnquist Court. The decision here came to a 7-2 decision where we have Justice Brennan and Justice Thurgood Marshall having a couple of dissents here. So let's get into it. Of course, this summary and breakdown is from oye.org, and they do an amazing job over there, everyone. So if you go over there, you can even listen to oral arguments of the original cases. It's just an amazing resource available to the public. So let's dive in. Here we go. On January 13th of 1985, Erwin Paul Wallaker, the treasurer of the San Jose Coin Club, returned home with the proceeds from the annual coin convention, which Terry Bryce Horton attended. Upon entering his garage, two robbers accosted Wallaker. One was armed with a machine gun and the other with an electric shocking device. They threw him to the ground, shocked him, bound him, and robbed him of jewelry and cash. During this interaction, Wallaker was able to identify Horton by the sound of his voice. The three witnesses who discovered Wallaker partially corroborated his identification of Horton. They saw someone leaving the scene carrying what looked like an umbrella. Sergeant LaRote determined that was enough evidence to search Horton's home and obtained a warrant to do so. His affidavit for the search warrant described both the weapons and the proceeds of the robbery. But the warrant only granted permission to look for stolen property. While searching Horton's house, Sergeant LaRoute did not find the property. He did find an UZI machine gun, a .38 caliber revolver, two stun guns, and a handcuff key, along with other items linking Horton to the crime. The evidence was admitted into evidence at trial, and Horton was found guilty. The California Court of Appeals affirmed that verdict, and the California Supreme Court denied the petitioner's request for review. So what's our legal question in this case? Does the Fourth Amendment prohibit the warrantless seizure of evidence in plain sight if the discovery of such evidence was not inadvertent? And here's our conclusion. The answer, no. Justice John Paul Stephen wrote for the 7-2 majority, held that the seizure of evidence in plain view does not constitute the invasion of privacy that the Fourth Amendment is meant to protect. Once an officer has a warrant to search a suspect's home, that officer may seize any obviously incriminating evidence that the officer finds in plain view. The court also held that the inadvertent limitation does not limit the scope of the search further than the warrant itself does. In this case, since the warrant was specifically for the stolen property, the officer had to limit his search to the likely places where the property might be kept. Since the officer also had probable cause to believe that certain types of weapons were used in the commission of the crime, he could legally seize the weapons if they were found in the course of the search. Now we've got Justice William Brennan, who wrote a dissenting opinion in which he argued that the Fourth Amendment requires police officers to obtain specific warrants from impartial judges and to limit their searches to the items described. He defines the inadvertent limitation much more narrowly, and it applies only when the officer is legally in a location and did not anticipate the discovery of such evidence. And with that, Justice Thurgood Marshall joined in the dissent. So that's the ultimate ending here. This is an incredibly important case because, of course, under the Fourth Amendment, we have the warrant clause. And so any search done without a warrant is immediately going to be viewed as suspect. But there are some exceptions. And in this case, we now have the plain view exception that has been hashed out quite a bit more now. So plain view exception, and when you are going in to search a place, if you come across some other contraband during that search, as long as you're there legally, then that other contraband can be picked up. So there you go. This is the landmark case from the U.S. Supreme Court defining that unreasonable searches and seizure piece of the Fourth Amendment, along with a little bit extra information on how warrants can come into play in this situation.